Yes, as far as the issue of our adherence and sometimes reluctance to embrace international law, and maybe this is best for Mary Ellen and David, but Philippe, please join in as well. It's my contention that I mean, our primary founding document, as much as I love the Constitution and to interpret the Constitution, is not the Constitution, but is the Declaration of Independence. And in the Declaration of Independence, we have the expression of certain inalienable rights that are endowed by a creator. These are natural rights, which really form the basis for a lot of customary international humanitarian law. And it's expressed in that document as, of course, life, liberty, and the pursuit of happiness. But we go on, and that document really kind of lays out a notion about international law and when certain nations might be appropriate to rise up, when certain peoples might have to rise up against a tyrannical form of government. And I think that in that document is perhaps one of the clearest articulations of an originalist notion that we, in fact, very much embrace international law. And embrace a law of nations before that really existed in a real sense. And I'm wondering if you think that this is perhaps something that we ought to be re-embracing as a driving force behind us saying, yes, we are committed to international law and international law norms such as customary international humanitarian law.
I absolutely agree, Michael, that in the research I did for the book on the power and purpose of international law, I really wanted to get to this question: why is international law treated so poorly on law faculties? Why do people seem to dismiss it, not consider it very important? Many of you may not know that for a period in the 1980s, 5 of our 10 top law schools didn't have a professor of public international law. And for a country, as Michael correctly described, that was founded on this understanding of the essential nature of international law for the very definition of statehood, for our privileges and rights in the club of states, that's just extraordinary. It would have been extraordinary to the drafters of the Declaration and of the Constitution. And I think I give the story. I had a wonderful insight from Withhold from the University of Alabama, a wonderful legal historian, who said that as positivism really rose as the only acceptable legal theory in the United States, our law professors, our judges, our lawmakers couldn't understand how you could have an international law because there was no legislature. There was no tangible institutions of lawmaking. Once they had lost the understanding that you can have lawmaking outside of those kinds of formal institutions, you can have other ways of doing it, that the authority of international law and all law actually rests in acceptance and belief, these non-material sources, and that we've always had these peremptory and higher norms, that this is part of all law. We came into this notion that things were that people couldn't accept international law, and I think we have to get back to an authentic understanding of what international law really is, and really educate ourselves much more fully in that. I would just add briefly that we're confronting a movement in theory in the United States in which the movement is away from what you just suggested. There's a very determined group of constitutional law scholars who want to argue that international law, all of international law, is part of state law. I find this absurd. And the great scholars, Louis Henkin, Philip Jessup, Harold Coe, have all said this doesn't make any sense. It's not true historically. But the top law reviews in our country, I just read a colleague's new article in which he makes this argument again. It will be published in the Columbia Law Review, that international law is not part of federal law. There's only 2 kinds, by the way, treaties and customary law, and it's part of state law, and that this is, and they draw on accurate historic evidence. So we're really in a moment of transition in many ways in this country, and how we reapproach international law, which Philippe and David made very clear. If we're going to actually be a success in the world, whether it's the economy or security or in advancing human rights or protecting the environment, we have to be fully engaged in a coherent way with international law through all our lawmaking institutions. But that's going to really take some effort on all our parts to resist and respond to this very wrong-headed notion of what international law is and where it is in our system.